Hello, my name is Lina Yusafi, and I'm a family lawyer and the founder of YLaw. I get asked a lot by my clients about how to prove that they're not in a common law relationship. This usually happens when one person has a lot of wealth and they want to, date another person, but they don't want their assets and incomes to be mingled or commingled or have to lose anything if the relationship ends. This usually happens in relationships where one or both people have been married and divorced before, and they just don't want to start the process all over again and get involved and lose more assets and income. So I'm just going to give some tips regarding how to prove that you're not in a common law relationship. Um, so the first thing to consider is you need to consider what a reasonable person would think looking at you and your spouse, whether they would think that you're merely dating or are you guys in a relationship that resembles a marriage, right? So a relationship that resembles a marriage is when your kids are kind of commingled, when you're living under the same roof, when you're physically and emotionally intimate, you're sharing the same shelter, you're under the same roof, you have joint bank accounts, and you're filing your taxes jointly. So that would tell a reasonable person that your relationship is more than a dating relationship. And if you took everything I said and kind of flipped it, and you didn't live together, you didn't have joint accounts, you didn't file your taxes together, you didn't mix your kids, and you didn't have sex, or you weren't very emotionally involved, then of course that resembles a relationship that is merely dating. And if you're dating, you are not subject to the Family Law Act, which would eventually say that you would have to give up a bunch of your assets and incomes on relationship breakdown. One shortcut for people to prove that they're not in a common law relationship is to get into a written agreement where they both acknowledge that despite living together, going on dates together, going on trips together, despite even sometimes having kids together, they're not in fact in a common law relationship. If these agreements are signed, even with the assistance of lawyers and legal advice, they do have a chance of being upheld and be considered valid. But imagine a situation where today you sign something saying, despite us living together, we're not in a common law relationship, but you end up being together for 20 years, and everything is commingled and your relationship really looks like a marriage-like relationship. Then you are still at risk to have these agreements canceled or set aside by a judge, because the test under the law is what an objective, reasonable person thinks of your relationship, not what you subjectively wrote on a piece of paper, such as, hey, it looks like we're married or we're in a marriage relationship, but we're not, right? So there's no harm into getting these agreements saying that you're not in a relationship. They are a part of your evidence, but they don't 100% protect you. What I usually recommend for people who don't want to be subject to common law is getting into these agreements and then saying, if for any reason a judge thinks that despite this agreement, we're still common law, then we still do not want to mix our assets or incomes. We don't want to give each other anything. We just want to go our separate ways. So you now have an extra layer of protection, such that even in a case where a judge finds that you guys are common law, the judge still wouldn't award the other spouse any part of your income or assets. I hope you found this summary useful and you're not too confused, but family law is sometimes technical and confusing. And if you want more clarity, look up our blogs or call us for a consultation at 604-974-9529 or email us at info@ylaw.ca. Thank you and have a great day.